was that he attempted to obstruct the proceedings of the House of Representatives by refusing to provide information and documents, which, if accepted, would reduce the impeachment power to an ink blot. That was voted, that was an impeachable offense. And when President Bush, even more egregiously, not only applies it to himself, but to his former aides, shoulders get shrugged. Oh, well. Because remember, it's the informing power of Congress. It's the oversight that it's most important, far more important than its legislative power. Sunshine is the best disinfectant. That's what really frightens the executive branch. Oh, we can't, if they think it'll be public, they worry. When they didn't think it would be public, that's all the lies that Scooter Libby and everybody else told about Valerie Plame and Joseph Wilson. The informing function of Congress. It's most important so that we, the people, know what our government is doing, and then we can evaluate whether we want to support or oppose, in the ballot box, in lobbying, or otherwise, what the president or Congress is doing or not. That's what self-government is, knowing what your government is doing. If you're blind, how do you know whether to support or oppose what's going on? Now, that doesn't mean that you necessarily have to show military plans of when this particular sidewalk is going to be hit. That, in fact, however, could be shared in executive session. But it means the people have a right to know the basic policies and reasons why the president is acting the way he is, so that people decide, I agree or disagree. And the way in which the people express their sentiments are at the ballot box, joining particular parties, making campaign contributions, all the kinds of things that politicians pay attention to. Now, to give you an example of the power of just publicity, there are threefold incidents recently that I think are very informative. Number one, you know that after the New York Times, this is December 15th of 2005, disclosed the warrantless surveillance program of the NSA. They called it the terrorist surveillance program. For an entire year, Congress held hearings about this program. Its legality, there was a white paper produced. It's rather amateurish, but at least it was something trying to justify the authority of the president to ignore FISA. All during that time, the president kept saying, and Attorney General Gonzalez insisted, the president has inherent constitutional power to spy however he wants, commit torture, break and enter homes, intercept emails without any regulation by Congress. This is part of his so-called unitary executive theory. I call it the counter-constitutional theory of the Founding Fathers, but you know, that would take an entire additional session, and I'm sure I'm overstaying my welcome anyway. So he had claimed for an entire year, nothing Congress can do can regulate my authority to gather foreign intelligence. But then suddenly, after criticism from many, including myself, although I don't want to be boastful, in January of 2007, suddenly, Attorney General Gonzalez said, now we've returned to FISA court. We've decided that, yeah, we actually can conduct foreign intelligence collection under FISA. And that happened for one reason. There was publicity. Can you imagine that would have been done if the New York Times hadn't published this program? Of course not. Another example. It's a little bit arcane, but it makes the point. For long years, when there was a vacancy in a U.S. attorney position, they typically serve 4 years, the federal judge in that district would have authority to make an interim appointment. And that interim appointment would serve until there was a successor. Well, in the Patriot Act, the Department of Justice said, well, that's wrong. We want the Attorney General to have the authority to appoint interim United States attorneys. Now, there is at least some skepticism for this reason. U.S. attorneys who are nominated as permanent have to undergo Senate confirmation. So you get the scrutiny and the ability of the Senate to evaluate the competence and character of the nominee. If you have an interim appointment and you keep an interim appointment and never submit a permanent replacement, then you can evade the Senate confirmation process. And the department repeatedly pledged, oh, we don't really intend to use the interim authority for that purpose, because they were driven solely by the New Testament. And when there were hearings held about the firing of U.S. attorneys, the 9, it was disclosed that indeed there was a plot contrived by Kyle Sampson, he was Special Assistant to Attorney General Gonzalez at the time, to try to get it. Tim Griffin was a friend of Karl Rove. They wanted to get him in as an interim U.S. attorney in Arkansas. His credentials were thin, to be euphemistic. And they thought, this is a chance we can get him as interim. We don't have to ever put his name up there. He can wait out the remainder of the president's term. And when this was disclosed through the oversight process, then there was a clamor, we need to go back to the old system. You deceived us. And President Bush signed the new legislation. And I guess gives us an example to show that we're talking about things that are more than academic importance. It has real influence on how the government operates. Real influence. And that's why to take away the power of informing the American people of what the government is doing, the oversight power, by saying, the president can say, you can't testify. You can't testify. I don't want to disclose what you told me or I told you. Goes to the heart of our ability to exercise self-government at all. Now, what makes this even more outrageous is that this claim of privilege in theory is based upon an entire fiction, a legal fiction. Namely that without confidentiality, presidential advisors would compromise what they said, or they would be worried or be silent, a fear that it would ultimately be disclosed. Now, having been in Washington 41 years, in government 15 years, read virtually every memoir that's been written by people who are less old than George Washington, I have never encountered anybody, including myself, who ever went into the Oval Office and said, Mr. President, I'm worried what I can say to you, because maybe this will leak out. Nobody. And indeed, George Tenet, in his recent book, he was former director of Central Intelligence. Remember his statement about the the slam dunk with regard to proof of weapons of mass destruction was reported in Bob Woodward's book, I think, Plan of Attack First. He says, of course, no one in Washington ever believes that anything, even in the Oval Office, will remain private. So the fact is, this privilege is for nothing. It doesn't protect any advice whatsoever. And of course, everybody walks into the Oval Office thinking this could leak. It happens every day. Look at or somebody will write a memoir and disclose it. You would really have to be an ingenue, to think that your advice to the president would always stay confidential. And of course, the president can waive the privilege anytime he wants. Of course, he would for his own purpose. And another additional mischievous element to this idea is that if you acknowledge the privilege, and then the president can waive it selectively, so it can give the public a wrong impression of what the facts are. He'll waive it for the good information and the bad and the ugly. I'll assert it then. So the public record is not really the truth, it's a half-truth, which is another word for a lie. So, what is to be done? There is no guarantee that we can turn this situation around, because this is not simply a Bush-Cheney problem. And it is not simply even a problem of the effeteness of Congress, most of whose members couldn't pass a 12th grade civics test on what the Constitution means. When they take their oath of office as required under Article 6 to defend and support the Constitution of the United States, they don't really understand what the Constitution means. Their mental universe is, what about my party, though? That has to come first. And I've gone up to say, do you find anywhere in the Constitution mention of Republicans or Democrats or Libertarians? No. Well, your oath is to the Constitution, isn't it? Well, what's the Constitution between friends? I mean, we got to move on to more important things. And that's the psychology up there. And that's the most dangerous element, ladies and gentlemen. It's the psychology. It's the psychology of a vassal, a psychology of indifference. A psychology says, nah, we don't really want to worry about freedom and checks and balances, the procedural protections against our own folly. We just need to worry about our own careers and how our party fares. We'll leave it like Scarlett O'Hara to tomorrow to worry about the important things that make the United States worth keeping, the United States of America as we inherited from the Founding Fathers.